realest niggas in this shit, man. I got the motherfucking streets, man. I came in the game with everything. I'm motherfucking.
Yo, is this thing on?
It's about respect to me. Love to see when I walk up in the club, a nigga run up on me, tell me I'm
You're
the
now
realest
listening
nigga
to the
living,
motherfucking greatest.
I'm the realest nigga in it. You already know. Got trap of the year 4 times in a row.
What they
A lifetime supply baking soda clientele.
What else?
A rolling watch, 2 pots, and 3 scales. Can get about 50 in the Hummer. The birds fly down south to Georgia for the summer.
Yeah.
Money, hoes, cars, clothes. Coke prices up and down like 6-fold.
Yeah. What up, though? What up, man? Welcome to the Trap Law Podcast. You could be anywhere in the world, man, but you're here with us, man, and I love you for that. I'm your host, the Trap Lawyer, a.k.a. your favorite lawyer can never, a.k.a. smack your favorite. Say nah. All right. But before we begin, man, it's important to note that the Trap Law Podcast is for educational and entertainment purposes only. All right, we break down the law in plain language so you can understand it. All right, but this is not legal advice. If you need legal advice, seek legal counsel in your in your respective states. See, look, man, we gotta get that right. In your respective states. All right, we're here to give you knowledge. We're here to give you power. We're here to give you perspective. But we are not here to create an attorney-client relationship. All right, with that being said, welcome. As evidenced by the title of this podcast. All right, we're talking about contracts today. All right, it's unpopular statement. Your contract is only as real as your ability to enforce it in court. All right, I'm gonna say that again. Your contract is only as real as your ability to enforce it in court, man. The reason I like to view contracts from an enforceability perspective is because I look at it as a puzzle, right? You're trying to build something here. With the necessary pieces, that's how we put it together. All right, our end goal is an enforceable contract. All right, we're gonna build this piece by piece. Okay, so today we're focusing on enforceability. So what that mean? We're not talking about what the contract says. All right, we're not talking about how you felt when you signed it. All right, we're not talking about what you agreed to or what you thought you agreed to, not what you assumed, not what a nigga had told you, none of that, right? But whether it can survive in the court of law. All right. So what is a contract? Well, I mean, at its core, everything is a contract, right? Your existence is a contract. You living in the United States is an unwritten contract between you and the United States government. All right. When you were born, you signed a contract by living here. All right. By breathing, by eating, all right? And under this contract, under the Constitution, the United States, you swore by being an American that you will be afforded all of the rights and privileges afforded to the American people. However, you also agreed that to be bound by all the restrictions and the regulations of the American people. So when you shot that nigga, right, you're not going to jail simply because you killed a man. That's very true. That's also true. But you're going to jail because you had a contract with the United States of America under the Constitution that you would not engage in that type of reckless-ass behavior, all right? You breached that contract of duty, you're going to jail, all right? So when you're asking yourself, is my contract enforceable? All right, there's 3 things we need to be looking at. 1, offer. 2, acceptance. And 3, consideration. We're going to start with an offer. All right, so what makes an offer enforceable? All right, if you're rocking with me, you already know how we get down, but if you're a first-time listener, when you're dealing with legal terms of art, we're dealing with this. My bad, y'all. My man's in the back. He's doing his thing, man. We can keep rolling, yo. Hey, shout out to D, my nigga Rocket here. You know what I'm saying? We're going to hold it down. When you're dealing with legal terms of art, all right, you're dealing with elements, all right? We're going to go back to the pieces. In order for an offer to be an offer, it has to have 4 things, all right? Clear, definite, communicated, and a present intent to be bound, all right? It has to be clear. You have to know exactly what's being promised to you. Definite. There can be no missing essential terms, all right? Communicated. You couldn't have heard it through a grapevine. You couldn't have read it on Instagram. None of that type of hot shit. You had to have been communicated directly to the person who was offering. And for a present intent to be bound. So not one day, not someday, but right now. All right, if any of these are missing, unclear, legally defective, all right, then your contract is weak. It's unenforceable. So what counts as a real offer? All right, so we already stated, we understand that it must be clear, it must be definite, it must be communicated, must have a present intent to be bound. Let's go over some enforceable examples, right? All right, so say for instance, a record label sends a contract. All right, record examples like, hey, yo, look, we want to offer you a 3-album contract deal with a $200,000 advance, 18% royalty rate. All right, is that an offer? 100% is an offer. Why? Because it's clear, it's definite. You understand what's being communicated to you and the intent to be bound today, right? Say, for instance, you got a producer agreement, right? Producer hits you, he say, hey, listen, I'll produce 5 beats for you, 7,500 each, delivery in 3 days. All right, do we have an agreement? Yeah. All right, do we have an offer? Absolutely, we have an offer. All right, what about a distribution deal? All right, we'll distribute your next 2 projects exclusively through our platform in exchange for 20% of your net revenue. Is that an offer? I guess so, nigga. You was right the first time. Don't second guess yourself, bro. Absolutely, it's an offer. Why is it an offer, right? It's enforceable, and it's an enforceable offer because you understand what's being promised, who's promising it, what the obligations are, and what the exchange is. Okay, so let's go through some unenforceable examples. All right, say for instance a label rep hits you in the studio. He like, hey, look, bro, you cooking right now. We love what you're doing. You know what I'm saying? We definitely want to sign you. We'll figure out the details later. A Diddy contract. Pause. A Diddy music contract, not the other Diddy contracts. You heard? You know what I'm saying? Do we have a deal? Is that an offer? Nah, I like that term. It's vague. Absolutely. It's too vague. We don't have any definite terms. All right? There's no present intent to be bound. He talking about figure out some details later off in the stratosphere. Nigga, we don't live there. We live here. Okay? All right, what about a DM, right? You get a DM, hey, cuz, look, you cooking, we want to work with you. Let's cook up a deal soon. No, absolutely not. That's a statement of interest, right? It's a nigga telling he like you, pause. You know what I mean? That might be cool for some niggas. Shout out to niggas who like that, but you know what I mean? That's not going to cut it in the court of law. What about a manager saying, once you blow up, we'll get you under contract? Absolutely not, right? Because, again, there's no present intent to be bound. That's some future shit out in the future, right? So let's get a technical. TLC, right? For all my people born after 2003, you might not know who TLC is, but TLC was a super hip hop and R&B group in the 90s. Crazy, sexy, cool, don't go chasing waterfalls, all that good shit. Hella millions, they styled out, right? All right, so in 96, they took LaFace Records to court. They sued them. All right, over some money, of course, some money was missing. All right, TLC filed this lawsuit against LaFace Records, challenging the validity of the contract. They saying it should be unenforceable. They argue that their agreements with LaFace and Peppertone at the time were unconscionable. All right, the terms cited low royalty rates and deductions for massive expenses. All right, so what's unconscionability? What's unconscionability, Trap? I'm glad you asked me. All right, what does it mean for a contract to be unconscionable? Well, an unconscionable contract, unconscionable, you gotta make sure we pronouncing that shit right. Yeah, you gotta get it right behind me. Ding. Unconscionable contract is one that's so grossly unfair, so one-sided, so oppressive that a court refuses to enforce it. All right, now why is this important to what we're talking about? Because unconscionability goes to the terms of the offer, all right? It goes to the behavior around the offer. The offerer is the master of the offer, all right? So when TLC went to sign on, they went on to sign that settlement agreement, of course, eventually, working out the numbers, everything worked out, but they were able to leverage the law surrounding the contract. And that's the only way. A contract is binding until it isn't. I'm gonna say that again. A contract is binding until it isn't. This is important for everybody who's looking to draft solid contracts, right? Right? For your business, for your personal life, however it is that you're looking to do, again, Diddy contracts, right? Or those who are currently in contracts that are unfavorable. and you're looking away to legally opt out of it, you want to think about the last time you did a deal with somebody. Could you write down on paper exactly what the other party committed to you? If you can, it's likely you have an offer. If you can't, it's likely you just had a conversation. All right? So when is a contract signed? Right? This is or acceptance. All right? Well, legally, acceptance means, again, we got a legal term of art, so we're gonna go into some elements, right? Acceptance means, or in order to be acceptance, there must be a mirror to the offer. Okay? Under common law, this is called a mirror image rule. All right? That means the acceptance must mirror the offer. It must look exactly the same. If I offer to sell you this pen, all right, we got 5 of these pens for $100 each, delivered 2 days later. All right? Well, your acceptance in this case is say, I accept your offer for 5 of these pens, $20 each, 3 days later. That's an absolute must under the common law. All right? So it must mirror the offer. It must be clearly communicated. All right? Must be clearly communicated. It must be made by the person who received the offer. What do I mean by that? You can't accept the deal by talking to the wrong person. All right, if I want to sign Pac-Man Jones to a deal or NFL contract, I can't talk to his mother. All right, I can't talk to his brother. I can't talk to his aunt. I can't get a promise from them saying that he's going to sign. It's not how it works. And then finally, this is a catch-all, all right? It must follow any method required by the offer. Okay? So if I put in a term in a contract that says, hey, listen, in order to accept this, you have to email me back. Well, that's the only way we can accept it. All right? And it must govern by that. Real quick, we're just going to talk about some overarching rules, common law versus UCC. All right? When you're looking at a contract, in order to know what law is governing, you need to know what's happening. All right? So under the common law is for service contracts. If I have a contract for to fix your lawn or to clean your house or any of those type of things, right? That's governed by common law, which is common to each state, all right? However, if I'm selling goods, products, beats, merch, et cetera, these things are governed by the UCC, all right? The Uniform Commercial Code, all right? It's important to know because acceptance differs under both of them. When you're talking about the UCC, if I'm selling goods, I can accept simply by performing. Well, what do I mean by that? All right, so say, for instance, you send me a beat, right? You send me a beat in a contract, but I ignore the contract and I just rap on the beat. Like, all right, fuck that. I'm about to, I ain't about to, you know what I'm saying? We gonna you know what I mean? We gonna run it up on this nigga real quick. Well, when you put that verse on a beat and you put that beat out, you have now accepted the terms of the contract, even if you have never read it. Because he sent it, exactly. See, my niggas is getting it, you heard? All right, we getting through out here. Let's go through some enforceable acceptance examples, y'all. Forgive me, okay? All right, real quick, it's kind of simple, right? Signing a record contract sent by the label. Acceptance? Okay, all right. Sending an email saying, I agree to these terms when the offer is written. Acceptance? Right, easy, all right. Clicking I agree on a digital beat license. All right, acceptance? Absolutely, all right. Here's the UCC twist, like I said. Anytime you have you're contracting for goods, under the UCC, performance is acceptance. Producer sends a beat, contract, artist uses the beat, releases it. This is acceptance by conduct. All right, unenforceable acceptance examples. Say, for instance, I send you a message on DM or something like that, right? Niggas love to DM and shit. And I send you a message. I send you an offer. The offer is valid, and you just hit the like button on it. All right, is that an acceptance? No. Nah, absolutely not. Absolutely not. It might mean that you just like what I said, but no, we ain't have it. Okay, so say, for instance, I give you a legal contract. I email it to you. You call me. I bet. Yeah, I'm down. But the contract required a written acceptance to it. All right, did I accept the contract? Absolutely not. Absolutely not. Because the contract required it, I didn't abide by the contract, there is no acceptance. All right? And then lastly, accepting different terms under the common law. This is important, all right? This is important because if I send you a contract stating I'm gonna sell you 5 of these pens, $20 each, all right, 5 days from now. But you say, I accept 5 of these water bottles for $10 each to be delivered a month from now. The terms are completely different. We don't have a meeting of the minds. There is no acceptance. All right, let's get to we're gonna get to another example. For all my people born before 2003, all right, recently there's this new rapper called Lil Nas X. All right, all right, not Nas, not to be confused with Nas, man. Shout out to Nas. All right, we ain't gonna do that. You know what I mean? But in 2018, Lil Nas X purchased a non-exclusive license from a beat producer named Young Ko, right, for $30. All right, that beat went on to become what we know now as Old Town Road. This initial lease agreement, typically which would only last for like 3,000 copies. All right. However, the contract stipulated that Young Ko retain 50% of his publishing share, no matter what you did with it. Absolutely. As you can guess, Lil Nas X had no other choice. All right, he couldn't argue, even if he wanted to argue that his intentions to contract wasn't to contract with him or to accept any offer. All right, when he recorded that song and he put that song out, the UCC deemed him to have accepted the contract plus the terms of the contract. All right, now he might have an argue over the fairness of the terms of the contract, but I don't even think it was great. The song was so big that the nigga was like, you know what, hey, take this little piece right here. That ain't nothing. I'm still making, you know what I mean? Them royalty checks still coming in a mill. Like I ain't, you know what I mean? So for all my artists, purchase plus download equals acceptance. All right? Purchase plus downloads equal acceptance. It's easy math, my nigga. All right? More of the story is, don't just be out here doing shit. You know what I'm saying? Move with intention, okay? The business world is a real world, you know what I mean? And what you allow or you ignore can bind you. All right, what you allow or what you ignore can bind you. All right, and then now lastly, and most importantly, if you ask me, the last element is consideration. Okay, now we get into the heart of enforceability. All right, each party must exchange something of legal value. All right, if only one person is giving something, you don't have a contract, you just got a gift. Simple. Well, it sounds simple. All right. Think of it as a balancing scale, all right? Every time you're thinking about enforceability or as far as considerations, just put your 2 hands up like this, pause, all right? If a label, so we're gonna go over some enforceable considerations, right? Say a label gives in advance, the artist gives his master rights. That consideration? Yes, absolutely it's consideration. Both people are giving something, okay? Producer gives a beat. Artist pays a fee. Is there consideration there? Absolutely. Both people are giving something and they're exchanging it. There you go. Recruit, absolutely. All right. Manager gives services. Artist gives a percentage. Absolutely. There we go. The common theme here, and the easiest way for you to digest it, pause. The common theme here is detriment. There you go. Each party is giving something. Therefore, each party is losing something, all right? There has to be a mutual loss in order for there to be a mutual gain. Simple. Damn, I should have been a poet. That was good right there, nigga. There has to be a mutual loss before there could be a mutual gain, okay? All right? Unenforceable consideration examples. Say, for instance, I make a promise to make somebody famous. You know what I mean? Hey, look, I promise to make you famous. Nah. Not consideration, right? Because there's nothing definite there. There's nothing definite, and you're not losing anything. You know what I mean? You could probably make me famous just by putting me on your magazine, nigga, you know what I'm saying? Or whatever the case may be. Yo, R. Kelly and Diddy, bro, that's what we doing today? Oh, man. R. Kelly and Diddy, bro? All right. A deal where a label can walk away anywhere, but the artist can't. Say, for instance, we sign a deal, the label will say, hey, look, anytime in this deal, I can walk away from it, but you're obligated under this deal for the next 10 years. Absolutely no. That's illusory. there's no consideration there. All right. What about past consideration? This is important. This goes into the present intent to be bound over in the offer, right? You can't pay me today or contract to pay me today for some shit I did last week, bro. All right? It ain't happening, bro. All my niggas, I know we want to, you know what I'm saying? If I did some shit for you, you owe it, my nigga. You can't contract with me today for some shit I already did. All right? Everything has to be now and in the future. All right? Example, Megan Thee Stallion, verse 1501. All right? Okay? Megan Thee Stallion, verse 1501. She challenged this contract. All right? The contract, she's claimed the contract lacked necessary consideration, and it was unfairly one-sided. All right? What is something that's unfairly one-sided? Now, what's the name of it, though? We went over it earlier. Yeah, that word. Yeah, unconscionable. Yeah, you got it. All right, you got it. There you go. All right, so she argued that the contract lacked necessary consideration. All right, she's arguing that the contract lacked consideration because the terms were so oppressive that there couldn't possibly be a fair exchange and the contract should be terminated. But of course, we disagree. All right, the label gave you money. The label gave you promotion. The label took risk. There's absolutely consideration in that. All right, so consideration, contract enforceable, get the fuck up out of here. All right, one real quick. Say, for instance, I give you 20% of my business. Or I tell a nigga, hey, look, I'll give you 20% of my business when I get rich. And the guy says, all right, cool. Do we got consideration there? Absolutely not. Do we got an offer? Yeah. Not really. Why? Because no present intent to be, there we go. There's no present intent to be bound. All right. And the dude that just said, yeah, he's just cool with it. He's not giving anything in consideration. He ain't losing nothing. There you go. You ain't losing nothing. All right, my nigga. So how should entrepreneurs, artists, even my 9-to-5 workers, what's the game plan? How should we be looking at this, right? When you're drafting contracts between you and others for services or goods, we want to put together something that memorializes our agreement, or maybe you want to challenge an agreement that you're already in. You know what I mean? You think the terms are unfair or oppressive. All right, these are the kind of factors you need to keep in mind. Number one, get the offer in writing. All right, get the offer in writing. Let me give you an applause for that. If it's not written, nigga, it's not real. You heard? If it's not written, it's not real. That's it. Period. Number two, clarify acceptance requirements. All right. Do we need acceptance by email? Is there a signature needed? Digital. Don't just assume. You know what I'm saying? Know for a fact how you want the contract to be accepted. If you can avoid any of these things, you can avoid challenges in your contract. You know for a fact that terms that you agree with, if they are good, they lock there. You know what I'm saying? A contract ain't shit if it's not enforceable. All right? 3, ensure consideration is flowing both ways. What we saying? That scale, right? They can cancel whenever. It's not a contract, nigga. It's a trap. Number 4, the UCC awareness, all right? You got to know what world we're in when we're dealing with contracts. At the top of the paper, my teacher used to always say, we start at the top of the paper and go down, all right? So at the top of the paper, we need to know what world we're in. Are we in the common law or are we in the UCC? You get what I'm saying? If we're in a service contract, we know we're in common law, we dealing over here. All right? If we dealing with products and goods, we're in UCC, we know we're over here. Now we can actually know how to move forward with it, right? And then 5, know that enforceability is power, right? All right? A great deal you can't enforce is worse than no deal at all. All right? A great deal that you cannot enforce is worse than no deal at all. Ladies and gentlemen, that brings us to the end of this episode. All right? You could have been anywhere in the world. but you was here with us, and we appreciate you for that. All right. On behalf of the good folks over at Trap Law University, I hope we added some value to you today, man. In the time we shared, some keys, some jewels, some laugh. You know what I'm saying? Me and my nigga D, my nigga Rock, you heard. If you enjoyed the show, rate us, man. Apple Music, Podcast, Apple Podcast, Spotify Podcast. We on YouTube now, smacking niggas in the head on YouTube. Come holler at us, like, share, comment, like, share, comment, like, share, comment. All right? And just remember this, man. Protect yourself, protect your art, protect your business. Stay sharp, stay focused, stay dangerous. It's your boy, the Trap Lord.